Hi, friends. Welcome back. This is Class 10 of Legislation on the Regulatory State here at Cleveland Marshall College of Law, your online law school. It's Learn and Law, Live in Justice, or as I like to say, 3LJ, every day, every way. Okay, so today we are going to finish up, believe it or not, statutory interpretation. This assignment will be the last two cases in our reading materials for statutory interpretation. These two cases are different, and they serve different purposes in the reading assignment. Smith versus United States finishes up something that I think we've been doing, which is sort of like last-minute housekeeping, last-minute cleaning up, squeezing in a bunch of sort of miscellaneous rules that are also useful to the courts in doing statutory interpretation, in addition to the big ticket items, the big picture ideas that we learned in the first part of the semester, which was, what is ambiguity? Why is ambiguity important? Why does it matter to judges who are textualists? How do judges approach the text, and when do they consider matters outside of the text, et cetera, et cetera. So for a while now, we've been in sort of more miscellaneous, more detailed application of rules, like, for example, in our last reading assignment, we learned the rule governing technical meaning in Nitz versus Hedden. We learned something in Moscow versus United States, which was that unlike the general rule for technical meanings, which is stated in Nitz versus Hedden, when a word has a technical legal meaning, then, in fact, the technical legal meaning is presumed, it's preferred, whereas ordinarily when technical meanings are available, if they're non-legal in nature, if they're scientific, for example, or if they have some specific meaning in commerce or trade, then the ordinary meaning is preferred unless the intended audience is appropriate to that technical meaning. All right, well, anyway, so we've been dealing with a bunch of miscellaneous little rules. In Smith versus United States, we're going to see one little thing about how courts use dictionaries. Sort of a last issue that the authors wanted to give us in the miscellaneous wrapping up of details is this fact that modern courts actually make reference to dictionaries a fair bit. We're going to ask why they do it, how they do it, what significance it has. Okay, well, that's Smith versus the United States. Kind of the last, what I want to say, the last case we're going to read that sort of introduces a new idea. ExxonMobil versus Allapattah. The authors threw in, and I included in our reading assignments, as sort of a last opportunity to sum up the current status quo of statutory interpretation in the federal courts. Okay, so let's talk about Smith versus the United States. So in some ways, this is one of my favorite cases to read because it's so sort of extraordinary. The facts are amazing to me. And above all, such a huge, serious consequence is made to depend on such a minor little distinction. The difference of opinion amongst 9 individuals over what one specific word means, one very mundane little word, the word use. Okay? But the meaning of that word use was the difference between 5 years in prison and 30. Okay, so anyway, let's talk about the facts just briefly. In Smith versus United States, the defendant in this criminal matter, this very serious criminal case, was Mr. Smith. He is a drug dealer. Apparently this was not his first brush with the law or his first engagement in this activity, and he's a fairly serious person and appears to be rather dangerous. He carries around a machine gun that has a silencer on it. Anyway, Smith, who lives in Tennessee, traveled to Florida hoping to buy cocaine that he intended to take back, I gather, to Tennessee and sell. While he's in Florida, he works with an acquaintance, a woman named Deborah Hogue. She connects him with some other drug dealers and helps him work out drug transactions. During the course of one of those meetings, the other party, the seller of drugs, notices that Mr. Smith has this particular gun, which the seller of the cocaine thinks is a good gun and expresses interest in buying it. Turns out Ms. Hogue is working secretly as an undercover witness for the cops. So with a tip-off from her, the cops set up a sting operation. An officer appears undercover, presents himself to Mr. Smith, offers to buy the gun. Importantly, however, he purchases the gun not with money, but with drugs, cocaine. So the issue in the case, that is the uncertainty that we have to solve, the legal uncertainty on which the case hinges, in this particular case has to do with the word use. So we have a federal statute that says if a person uses, quote, a gun in connection with a drug transaction, that automatically requires a sentence enhancement. So in addition to whatever other crimes the person happened to have committed, their sentence has to be increased if they also happen to use a gun in connection with that transaction. More specifically, we're told on the top of page 165 in the third edition, this is from 18 U.S.C. section 924C1. Title 18 in the United States Code, by the way, is federal criminal law. So almost all federal crimes are contained in Title 18. 18 U.S.C. 924C1 says that additional penalties have to be added if the defendant, quote, during and in relation to any crime of violence or drug trafficking crime, uses or carries a firearm. Okay, so that's pretty broad. If there's a crime of violence or a drug trafficking crime, and trafficking, I'm no criminal law man, but trafficking means that you're buying or selling large amounts of drugs. If you use or carry a firearm in connection with such a thing, and remember, it has to be during and in relation to. But if you got a gun and you use or carry it during and in relation to such transaction, then you get this sentence enhancement. Moreover, the statute says if the gun happens to be a quote-unquote machine gun, then the sentence enhancement isn't an additional 5 years, it's an additional 30. So the consequences for Mr. Smith were life-changing. Presumably his life was effectively over, depending on what these justices considered the word use to mean. Interesting fact. Something happened here again, just like we saw in the Moscow case. Remember, Moscow was the case in which a fella took used cars with falsified, doctored odometers across state lines, got falsified titles to reflect those odometer ratings. And he was charged under a statute. He was indicted under statutory language that made it illegal to carry, quote, falsely made securities across state lines. Funny thing was, there were other words in that statute that he wasn't charged with, and we talked about that a fair bit. It's not exactly clear why he wasn't charged with those things, but because he wasn't charged with any other words under the statute, it was incumbent on the prosecutor to prove that his conduct constituted, the documents that he carried constituted falsely made auto titles. Same thing happened in this case. The statute prohibits both using and carrying a firearm during and in relation to a crime of violence or a drug trafficking crime. But this person was only indicted for using a firearm. That's pretty interesting, if you ask me, because the whole thing is, no one in this case seems to dispute the most natural meaning of use in this circumstance seems to be use as a weapon. Justice O'Connor doesn't really seem to deny, if you ask me, that the most natural meaning of the language he's indicted under is to use a gun as a weapon, to go pew-pew. This fellow didn't do that. Nobody believes that Mr. Smith used the gun as a weapon, but surely he carried it, right? I mean, he took the gun with him in a canvas bag to a deal that he knew was a transaction in a substantial amount of illegal drugs. So presumably he carried the firearm, and why the prosecutor wouldn't charge him, or the grand jury wouldn't charge him under that seemingly more fitting language is a little mysterious to me, and we're not told. But nevertheless, he is not charged with carrying, so it is important for the majority, or for the court, to determine what use means and whether using a gun as something other than a weapon in a drug trafficking crime can constitute use. Okay, well, This is one of those cases in which you've got a majority and a dissenting opinion that come to opposite conclusions, as they always do. But they both do, if you asked me, simply virtuosic work. Both opinions are masterful, very careful, full of very thoughtful insights, full of persuasive evidence, both in the form of raw logic, but also in the form of contextual evidence from other words in the statute, thoughts about the actual reasoning of the purpose of Congress in enacting this thing, and it's just hard to know who's right. I'll observe a couple things. Top of my head. In one way, it seems like Justice O'Connor for the majority, reaches an extremely harsh result on a broad reading of the word use. Moreover, as Justice Scalia says, we even happen to have a rule of statutory construction that could have helped Mr. Smith and saved his life in a way, could have saved him 25 years in prison. And that is the rule of lenity. All right, so Justice Scalia rests on the rule of lenity. Justice O'Connor acknowledges that rule exists, but rejects it in this case because she says there isn't actually any doubt that this fellow's conduct can fit within the meaning of use. Okay, so it seems, it might strike a person as kind of a crazy result that the majority reaches, if nothing else, because it's so harsh and it could have been avoided. But, Justice O'Connor makes an excellent point. She says, look, this guy's engaged in serious drug crimes that are among our more serious crimes, and he's showing up with a machine gun. Like, if our question is, what did Congress intend? It is actually perhaps plausible that Congress intended to punish a person quite severely who shows up at a serious drug transaction with a very dangerous weapon. Moreover, Justice O'Connor doesn't quite say this explicitly, but after all, Congress did in fact impose exactly the same penalty on a person who merely carries a machine gun to a crime of violence or a drug trafficking transaction. Right? So it may be a harsh result, but it does actually seem pretty plausible that it's a result that Congress intended. That sort of reasoning poses a couple of interesting problems, though. First of all, Justice O'Connor, she's politically a conservative justice, and again, modern conservative judges tended to gravitate towards textualism. They tended to favor trying to find the meaning in the text if they could. And, we saw in King versus Burwell, the Obamacare case decided by Chief Justice Roberts. Chief Justice Roberts wasn't even willing to try to consider the quote-unquote purpose of a statute. He wasn't even willing to look for the mischief at which the statute was aimed as an aid in interpreting the statute until he found that the statute was ambiguous. So you might think it's a little funny that Justice O'Connor would even mention that the purpose of Congress is perhaps served here, where we're reading a statute that Congress reaching a result that Congress plainly could have intended, imposing a harsh result on somebody who brings such a dangerous weapon to a drug deal. On the bottom of page 169 is where I'm getting that, by the way. Justice O'Connor says, look, restricting the word use, Justice Scalia, reading the word use a gun to mean using the gun as a weapon, does violence, she says, does violence not only to the structure and language of the statute, but to its purpose as well. Okay, so there could be a little bit of tension there. Where does this conservative judge, who probably, is pretty sympathetic to the textualist cause, where exactly does she get off saying, I'm going to consider the purpose? In part, it is offered as her response to the rule of lenity, right? The rule of lenity applies because this happens to be a criminal statute, And Justice Scalia believes that the language in question is in doubt, and therefore the rule of lenity applies. And Justice O'Connor points out in rebutting it, first of all, in her opinion, the language itself is not sufficiently unclear to require application of lenity. Moreover, she says, another reason to rebut this rule of lenity is, look, it'd make less sense. It would do violence to the words to apply the rule of lenity. The language is unclear, and the rule of lenity in this case would, if anything, make the language less clear. Okay, well, if you ask me, by far, the most masterful pieces of Justice O'Connor's reasoning appear before her discussion of the rule of lenity or the purpose of the statute or anything like that. She begins actually by relying on dictionaries. In some sense, this is probably why this case is in here, because the authors wanted to point out to us all that federal judges do this now, and state judges do as well. Sometimes it can get it can be a little surprising how heavily some modern judges rely on dictionaries. Some people have been very critical of this. I mean, sometimes judges rely so heavily on what different dictionaries say that it's almost as if they're delegating decision-making authority to the authors of dictionaries. They're giving dictionary authors authority to tell us what statutory language means, which surely wasn't intended. There's a very funny note, I thought, following the case on page 173. After some years in which federal judges more and more commonly were making use of dictionaries and actually fighting over what dictionaries themselves meant and citing different dictionaries at each other as authority for what statutes meant, people just started asking staffers and members of Congress, do you actually use dictionaries? And people in Congress say, no, we don't. Look these words up in dictionaries before we write them down. Some staffers said, we don't even have dictionaries. Does that mean that we shouldn't use this particular source of understanding what statutory words mean? I mean, it could be like other things we've talked about, strict interpretations, textualist interpretations, maybe are a way for the courts to communicate with Congress and say, look, this is how we're going to read your statutes. If you want us to do a better job, here's how we're going to read it. And here's how you can anticipate how we're going to interpret your statutes. Perhaps if the courts say to them, look, in cases of uncertainty, we're going to look up these words in dictionaries. So why don't you do the same? Like if you can anticipate that a word is going to be hard for the courts to understand, look it up in a dictionary and see if it's really the word that you think is the best word. In any case, we could ask ourselves, why is it that a court looks at a dictionary? In other words, what question is a court attempting to answer if it looks up a statutory word in a dictionary? No one believes that dictionaries actually have some sort of legal authority, right? Judges aren't saying that. So what are they doing? Well, it should be pretty familiar at this point. When a court looks up a word, statutory word in a dictionary, the court is applying that first and most basic rule. Or maybe it's not the first rule, but it's a very basic rule, which is courts presume that Congress intends the words it uses to have their ordinary meaning. Congress intends words to have the meaning that they would have to an ordinary speaker of English who is reasonable. The place to figure that out is, well, the dictionary. So that's what courts are doing, and that's what Justice O'Connor is doing on page 165 when she cites Black's Law Dictionary and Webster's New International Dictionary, and so on. All right. Well, I said that I thought Justice O'Connor's performance gets to be pretty masterful at a certain point, and it's really right after that. So turning to page 166, Justice O'Connor makes several points that I thought were quite impressive. As she says, top of page 166, she points out that language can't be interpreted apart from context. Okay, so this is interesting because we saw exactly the same thing in the Klein case, right? You can't understand the word use without reading it in connection to words that appear around it. And she acknowledges that use appears near the word firearm. And she acknowledges that, yeah, I mean, the most natural understanding of use a firearm is to shoot it. Firearms have a purpose for which they exist, and it is not to be consideration in commercial transactions. It's to be shot as weapons. Unlike Justice Souter in the Klein case, though, she doesn't stop with context. She doesn't say, well, there's only one meaning that this language can have because of a word that it appears near. She says that even in connection with the word use, even in connection with the word firearm, use could mean more than just shoot. And again, even Justice Scalia doesn't really exactly doubt that. He doesn't say it's impossible that a person could understand use a firearm to mean trade it as the purchase price of something. And here's where I started writing stuff in the margins of my book, like brilliant. On bottom of page 166, Justice O'Connor makes reference to an argument that Justice Scalia makes. Scalia says, in what I think is a clever argument, he says, look, when we say use a thing, what we ordinarily think is use it for its purpose. Use it for its intended purpose. Use it for its essential nature. And he says, think about a cane, a walking cane. There are ways you could use a cane. You could deploy it, have it perform a function other than walking with it. And his example is, well, maybe it's an ornate or sentimental item to you, this cane. Maybe it belonged to your grandfather, so you display it in a case in a cabinet in your home or something like that. He says, that certainly is within the plausible meanings of the word use, but that's not what we think when we think of the word use. Well, Justice O'Connor has a real snappy comeback, if you ask me. She says, cane is a great example because people use canes very commonly for things other than walking with them. And for example, they use them as weapons, which I thought was pretty clever. Just like a gun, you could use it as a weapon and you can use it for other things. As she says, there was a famous incident in Congress in the 19th century in which one senator beat another senator with his walking stick. Likewise, she says a cane can be used to punish someone, and that use is common enough that caning a person is in fact to hit them with a stick. Here's where I think she makes an extremely perceptive point. She says on the top of page 167, moreover, the question in this case is not whether the word use could include transacting, using a firearm as an instrument of transaction, as payment for something. And she says that because it can. Like, it makes sense. It's not crazy to say that I've used my gun to buy something. But here's what I think is very perceptive. She says, look, the question here is not whether it would be reasonable to include the word, to include the idea of transacting within use. The question is, would it be reasonable? Would a reasonable person read use a firearm to exclude conduct other than shooting a gun? And she says, no. She backs that up then by pointing out that use a firearm appears elsewhere in the statute, and indeed it appears very shortly after 924C1. In 924D, Congress said, moreover, if you use your gun in certain contexts, the government can confiscate the gun as a penalty. And among the ways that you could use a firearm and suffer the penalty of confiscation, forfeiture, is if you use it, on top of page 168, in an interstate transfer, sale, trade, gift, transport, or delivery. So in other words, Congress did in fact itself use the phrase use to describe a use of a gun in a barter transaction. Okay. Well, that leaves us with Justice Scalia. He also makes some use of dictionaries, but he mostly says, in his view, the plain meaning of use a firearm has to be more limited. use a firearm and means use it for its intended purpose. And again, we could go through this point by point, but Justice Scalia, suffice it to say, makes a series of extremely thoughtful, interesting points in response. For example, he says, in fact, he does believe that a reasonable person would understand use a firearm to exclude using it for some purpose other than shooting it. And you gotta love his line on the top of page 171. He says, it is perfectly reasonable to say that a person used their gun in a drug trafficking offense by trading it for cocaine. And Scalia adds, quote, it would also be reasonable and normal to say that he used it to scratch his head. But Congress probably didn't intend to put a person in prison for 30 years for scratching their head with a gun. All right. And finally, Scalia ends with his rule of lenity answer. Leaving us to the, and we already mentioned that Justice O'Connor rejected that. I mean, this leads us to the conclusion again. Leaves us in the position of a familiar awkwardness, which is pretty hard to say what the right answer was here. At least it seems hard to me. I think that both justices made extraordinarily able and persuasive cases, and I don't know which one of them is right. My personal instinct seems pretty harsh to throw a person in jail for a 6 times longer jail sentence over a debatable meaning of one word. But on the other hand, I'm quite persuaded that Congress very well may have intended that, above all because it also used the word carry in the statute. They'll throw you in jail for 30 years if you carry a machine gun to a drug deal. So it's just a little bit hard to say what the right answer is. As is so often the case, we ought to think just briefly about what we should take from this case if in fact it's left us with this sort of uncertainty. And once again, I just got to say, the point of all of these cases, in which there is no right answer and there won't be, is to learn what the arguments are, how do you make arguments for and against, and to understand how courts approach these problems. Smith versus United States is a nice example for you to think about in connection with exam taking in the following sense. You'll have an instinct in writing exam answers to state the issue and then jump right to the rules, to jump right to legal doctrinal rules, because you want to show off that you studied, you figured out what these rules mean, you wrote your outline, you figured it all out. If you do that, you're going to probably skip something. You're going to have an instinct to skip something that I'd like to encourage you to pay some attention to. And that is, no matter what the hypothetical question is, there's going to be, in your exam question, some fake hypothetical statute that I will have made up, and I will give you explicit language as if I'm quoting from a real statute. The thing you don't want to skip over is actually pay careful attention to the language. Think about the language. Think about what it could mean. A good exercise will be, think to yourself through the problem, can you identify an ambiguity? Can you identify 2 or more discrete meanings that language in the statute could have, that a reasonable person could, both of them could be reasonable, and choosing one or the other affects the outcome of the case, right? That's a pretty good exercise. You probably want to be able to do that if you're going to write an answer to an essay in this class, an essay question in this class, because there's probably going to be an ambiguity in there. All right, so Smith is kind of a nice example of how that works. I mean, these are 2 very smart lawyers who aren't really applying legal rules quite as much as they're just really carefully analyzing the semantic meaning of some words. All right, and you want to be able to do that. Okay, well, there's, like I said, a funny note following the case about the use of dictionaries. There's another, in specifically the finding that some academics have come up with, that members of Congress and their staff don't actually use dictionaries at all. There's another note which is funny or tragicomic, I guess, depending on how you look at it, on page 175. I'm sorry, I said that wrong. Page 177, under the note 3, the transaction in reverse. So something really bizarre happened. As if Smith versus United States wasn't weird enough, striking enough. We get a deal, a drug deal under exactly the same statute, except that it was flip side, mirror image. Instead of the defendant trading a gun for drugs, the defendant traded drugs for a gun. And the majority of the court this time said that's not using a gun. All right, if you the defendant who gives away drugs as the consideration to purchase a gun is not using the gun in connection with a drug transaction. Instead, that person is using drugs to get a gun. All right. So I don't really know what to say about that, except that it seems a little crazy. It's remarkable enough to spend a minute thinking about. Proof further that really, really smart lawyers, however much they fight about it, have trouble coming up with consistent answers to these things. Okay? All right, so let's turn to our next case, Allapattah. Okay, well, that brings us to a final case for today, and this is going to be the last case we're going to read in statutory interpretation. This is Exxon versus Allapattah Services Incorporated. This appears on page 232 in the third edition. This case poses a couple of problems for us. For one thing, I find it's always kind of challenging to figure out exactly where cases go in assigning them during study of statutory interpretation. And it's because so many cases involve so many different things that they don't sort of fit into discrete cubby holes. So it's a little hard to know where to stick them. This one, admittedly, stands out more than many do because it has some complexities, and also it's a little, it's maybe not exactly clear exactly why it's appearing here at the end. I'll address that in a second. A second difficulty posed by this case is just the pretty significant complexity of the underlying issues. So this federal jurisdiction issue is pretty complicated. And you kind of have to understand that just to figure out even what's going on with the statutory interpretation issues. So let me address those two things. First of all, the reason to talk about this case here is that the same reason that we've talked about some other cases. And it dawns on me, you can think of these, maybe I should have thought of these cases as all sort of belonging at the end. Like maybe I should have put them all at the end. But at various points in the semester, we talked about cases that kind of capture the current status quo, the current state of play in statutory interpretation in the bigger picture. That's certainly why your authors wanted to stick this case here. They wanted, after all this time we've spent in this semester so far, talking about sources of interpretive guidance outside the text, and above all, legislative history, which is among the more complicated or controversial problems in interpreting statutes. After all this time, it's useful to have a reasonably recent case. I mean, this is 2005. It's not like yesterday, but it's not all that long ago, in which members of the court who are more or less part of the current status quo gave their views on when judges can look beyond the text and when in particular they can look at legislative history. So, the alignment of the justices is Justice Kennedy for the majority. Justice Kennedy just retired a couple of years ago. And he's sort of a strong textualist, one of the strongest of those justices who really wanted to stick to the text. Sort of fighting with Justice Stevens. Stevens retired a little bit longer ago than that, but not all that long. And you'll notice another key dissent in this case was by Justice Ginsburg, who just passed away. So this is pretty much the composition of the very recent court, talking about how they view these things, and addressing one particular question in this problem of what sources can we look at beyond the text, and that particular material happens to be an important one. It is legislative history. Okay, so that's why we're talking about the case here. Now, the other problem the case poses is that to understand the discussion of legislative history and statutory interpretation, you kind of need to understand the underlying statutory issues, and they're pretty complicated and pretty unfamiliar to students who haven't had civil procedure yet. So let's just briefly talk about what's going on here. The question in the case goes to the jurisdiction of the federal courts. All right. Everyone knows in some general sense, I think, what jurisdiction is or what it can mean. And indeed, it turns out that word jurisdiction can mean several different things. It has more than one technical meaning, even as it's used in law. In this particular case, the question at the heart of the case is about the so-called subject matter jurisdiction of the federal courts. So let's give that some thought, and let's look at some of the underlying statutory language. So what is subject matter jurisdiction? Well, it's one of two kinds of jurisdiction that federal courts have to have in order to hear a case. On the one hand, courts also have to have what we call personal jurisdiction, which means power over the parties that will appear before the court. So a court has to have personal jurisdiction over both the plaintiff and the defendant in order to enter a judgment that will bind them both. That's a whole different topic. You'll learn all about it in civil procedure. Subject matter jurisdiction, then, is the power of the courts to hear particular kinds of disputes. So personal jurisdiction is power over the parties. Subject matter jurisdiction is power over the subject matter of the lawsuit. Okay, so it turns out that, but by the way, it may or may not be obvious, but this turns out to be more complex than I'm going to make it seem. But for our purposes, all we need to know is what I'm going to tell you. So subject matter jurisdiction, again, comes in two flavors. There is, first of all, the power of courts to hear matters that arise under this statute. Notice that this statute comes from a title of the United States Code, that is Title 28. That's the part of the United States Code, the codification of all federal statutes, that governs the judiciary. It creates the procedures and powers of the federal courts. So the first of the major types of federal subject matter jurisdiction is under the statute, Section 1331. 28 U.S.C. Section 1331 is the so-called federal question jurisdiction. It's very straightforward. It says that if a dispute arises under the Constitution, the laws, or treaties of the United States, in other words, under federal law, then the federal courts, obviously enough, have subject matter jurisdiction to hear that dispute. Okay, well, the second major source of subject matter jurisdiction of the federal courts is the diversity jurisdiction, as we call it, under Title 28, Section 1332. So this section is quite a lot longer than 1331. I gave you a second ago the entirety of Section 1331. Section 1332 is quite a lot longer than this, and I edited much of it out. All that's really important is that first part. The district court shall have original jurisdiction. That just means they have subject matter jurisdiction. You can file a case in a court that has original jurisdiction. Of all civil actions, so in other words, not criminal ones, where the matter of controversy exceeds the sum of $75,000 exclusive of interest and costs and is between citizens of different states. All right, so in other words, if it's not a federal question case, if the dispute between the parties happens to involve state law, the federal courts do in fact have original jurisdiction. You can file your case there, so long as the plaintiff and the defendant are citizens of different states. But very importantly, the amount in controversy, the amount that the plaintiff plausibly could win, if the plaintiff wins its case, is at least $75,000. Okay, so the dispute in Allapattah is about this subject matter jurisdiction. And let's think just in a little more detail about what exactly the dispute is. All right, and next thing to understand about Allapattah is that this particular case was brought under a thing called Federal Rule of Civil Procedure Rule 23. This thing is going to be very familiar to you about a year from now, once you're in CivPro and you've got CivPro under your belt. The Federal Rules of Civil Procedure are a set of rules that the courts must follow, federal courts must follow, in the administration of their trials. The federal rules are created by the U.S. Supreme Court pursuant to statutory authority. So Congress said to the Supreme Court, here's a statute, it's called the Rules Enabling Act, that authorizes the Supreme Court to make its own rules of procedure. And among other things, it created the Federal Rules of Civil Procedure. One of them is Rule 23. All right, so Rule 23 authorizes the federal courts to hear class actions. Again, I'm simplifying something that's pretty complicated, but generally speaking, class actions can be cases in which a number of plaintiffs all sue the same defendant. So that's pretty familiar to us just from reading the papers. Okay, the reason the particular class action in Allapattah raised a problem of subject matter jurisdiction was that the claims that those plaintiffs brought against Exxon, like I don't know the facts of the case, I didn't look it up, but there's some sort of dispute against Exxon that violates, according to the plaintiffs, involved a violation of state laws. Okay, so their only claims are based in state law. They're not alleging any federal causes of action, so there can't be federal question jurisdiction. The federal court cannot have subject matter jurisdiction under the federal question rule of 28 U.S.C. 1331. These plaintiffs, therefore, have to establish the so-called diversity jurisdiction under Section 1332. So diversity jurisdiction, like everything in civil procedure, turns out to be pretty hairy, pretty complicated, and it involves a whole bunch of other complexities. But one specific thing that plaintiffs typically have to bring, at least one plaintiff in a diversity action has to bring, is not only diversity, but they also have to satisfy that so-called amount in controversy requirement. Remember, Section 1332, let's just take a look again, requires that the district court shall have original jurisdiction if the dispute involves $75,000 and is between citizens of different states. So a question then is, what happens if a plaintiff brings a class action under that Rule 23? And there's a whole bunch of plaintiffs, really. Could be thousands. Does every single one of them have to satisfy all the requirements of the diversity jurisdiction rule? At various times in our history, the courts said yes. Every single plaintiff must be able to establish subject matter jurisdiction in the federal courts. And if they can't, they cannot be awarded recovery by the court. And therefore, if all we had were sections 1331 and 1332, and you got a class action like Allapattah where the only claims being alleged are state law claims, well, then everybody would have to satisfy both the requirement that the plaintiff not be from the same state as the defendant. In other words, they'd be diverse in their citizenship. But moreover, every plaintiff's claim would have to be worth $75,000 or more. So there's no dispute in the Allapattah case that some of the plaintiffs couldn't satisfy the amount in controversy requirement. Okay, and this was a pretty significant problem because the courts have taken the view not just that those plaintiffs can't recover, like the whole rest of the class can get a judgment, but the plaintiffs who can't satisfy amount in controversy can't recover. Though the whole lawsuit can fail if the class is defined in a way so that it could include people who can't satisfy the subject matter jurisdiction requirement. Okay, well, it turns out that there is additional hope for plaintiffs, however, because there are sources of subject matter jurisdiction in Title 28, in addition to federal question and diversity jurisdiction, and that brings us to the supplemental jurisdiction rule or statute, which is the statute that's actually at issue in Allapattah. So let's take a look at that. Okay, so this is the text as it currently exists. So this is after the amendment of 1990 that occurred before the Allapattah case. All right, but that's not hugely important right now. Importantly, let's take a look at subsection A there. It says, except as provided below or expressly provided otherwise in some statute, in any civil action in which the courts have original jurisdiction. So in other words, if a court does in fact have federal question or subject or diversity jurisdiction over something else, then the district court shall have supplemental jurisdiction over all other claims that are so related to claims in the action within such original jurisdiction that they form part of the same case or controversy. Okay, so in other words, let's say you got a plaintiff who can demonstrate diversity jurisdiction, and then some other plaintiff has really closely related claims, closely enough that the courts would ordinarily let those two plaintiffs proceed together in the same lawsuit. Now, it turns out there are actually a whole number of situations in which that can be done. It doesn't have to be a class action in order for two or more plaintiffs to proceed in the same action. All right, but in such a case in which a court would be willing to allow two plaintiffs to proceed together, if only one of them can demonstrate diversity or federal question jurisdiction, well, the supplemental jurisdiction might be available for that other plaintiff if it turns out that the two claims are so closely related that they form part of the same case or controversy. All right, they're really part of the same dispute between the plaintiffs and the defendants. All right. Well, a question might come up then if you got a class action, and some of the plaintiffs plainly can demonstrate some federal subject matter jurisdiction on which to found their action. Well, what if you define the class in such a way that you wind up having a whole bunch of plaintiffs who couldn't themselves establish federal jurisdiction, but their claims are really, really closely related to those plaintiffs who do have subject matter jurisdiction? Could the supplemental jurisdiction be available to help them bring their claims? All right, so the Supreme Court, in a case that's mentioned in the note that precedes Allapattah, decided two different cases that both said no to that question in different contexts. So there's this old case from 1973 called Zahn versus International Paper. It's discussed on page 231 that said, where some of the plaintiffs in a class action base their subject matter jurisdiction on diversity, and other plaintiffs named in the same class can't meet the amount in controversy requirement, in other words, their claims aren't worth $75,000, then the case is dismissible. The court cannot take supplemental jurisdiction over that class. In a separate case, a more recent case from 1989 called Finley versus United States, this is also on page 231, the court did a whammy on the other kind of original jurisdiction of the federal courts and said that if a class action is one in which there is federal question jurisdiction because some of the plaintiffs in the plaintiff class are alleging federal causes of action, if there are some other plaintiffs whose claims couldn't meet that kind of jurisdiction, in other words, they don't have federal causes of action, but they have state law causes of action that are so closely related in their factual nature that they're really part of the same case or controversy. Well, Finley said, too bad, sucks to be you. You cannot, federal court cannot take supplemental jurisdiction over those closely related state claims. All right, well, that brings us to Section 1367 and its amendment in 1990. So the 1990 amendment was in a statute called the Judicial Improvements Act. And among other things, Finley, which was apparently a very unpopular decision, was explicitly reversed by Congress in 1367. And apparently nobody disputes that, at least not in this case. Nobody in the Allapattah case doubts that 1367 was intended to and did reverse Finley. So in other words, if there is federal question jurisdiction, then closely related state law claims raised by other members of a plaintiff class can be part of the subject matter jurisdiction and are part of the subject matter jurisdiction of the federal court in that case, even as to plaintiffs who couldn't raise their own federal causes of action for whatever reason. All right, but this left open the question, what about Zahn? 1367A very broadly says the following. Except as provided in subsections B and C or other federal statute, district courts have where a district court has original jurisdiction, the court has supplemental jurisdiction over claims so related that they're part of the same case or controversy. Okay, so this whole case then kind of turns out to depend on what subsection B says. Okay, here's the thing. If you read this carefully, it does in fact say, in a civil action of which the district courts have original jurisdiction founded solely on section 1332 of this title, which is to say, federal diversity jurisdiction. Remember, 28 U.S.C. is the federal diversity jurisdiction statute. Then in that case, well, then the courts won't have supplemental jurisdiction over claims by plaintiffs against persons made parties under certain specific rules, 14, 19, 20, etc. Or likewise, by claims made by persons that the plaintiff brought in. So in other words, sort of counterclaims made by other people that the plaintiff brought in under rules 19 and 24. Okay, now the good news is that none of that nasty detail means a thing. We don't have to care about rules 14, 19, 20, or 24. It doesn't matter. What's crucially important is that one rule doesn't appear there. You may want to ask yourself briefly, can I say which rule that is? Well, which one is missing from this entire thing? Yes, you guessed it. It's Rule 23. So, Allapattah. So there's not actually that much to say about the opinions in Allapattah. The authors make a point of saying that the actual substance of the opinions, the disagreements between Justices Kennedy and Ginsburg, which mostly went to the major substantive disagreement in the case, were really complicated. Very sophisticated, very complicated. We don't need to try to get into that. Bottom line is, instead, that there is a dispute here over the proper use of legislative history in a way that brings us full circle, right? Legislative history is this thing we started off the very beginning of the semester thinking about. We were exposed to the fact in Tennessee Valley versus Hill that Chief Justice Burger in the majority and Justice Powell in dissent in that case, the snail darter case, both were quite happy to look at legislative history, and they relied on it significantly. And they didn't bother to find that there was ambiguity. There wasn't a need. In fact, Chief Justice Burger began by saying the language of the Endangered Species Act couldn't be more clear. Language is hard to imagine that could be more clear, less unambiguous, and yet he looked at legislative history anyway to support his view. Well, here in Allapattah, some 30 years later, we have quite a different court, entirely different personnel, or almost entirely different personnel, I think, but a very different court ideologically as well, and much more reticent in its approach to statutory interpretation. And a majority opinion by Justice Kennedy saying, I'm not going to consider any legislative history at all, and indeed, I cannot, or I won't, except to respond to Justice Stevens, evidence in his dissent, making arguments on something stated in a House report. And indeed, it is remarkable to see the Supreme Court so openly critical of members of Congress, virtually calling the House report an official report of the U.S. Congress, official work product of elected representatives in government doing their jobs. And the Supreme Court virtually calls this House report dishonest or fraudulent. As Justice Kennedy says, there's evidence that the people who drafted this thing tried to get something into the House Judiciary Committee report that's the opposite or quite contrary to what is stated in the language of the statute itself. That is, the statute seems quite clearly, according to Justice Kennedy, to prohibit, or rather to mandate supplemental jurisdiction over class action plaintiffs under Rule 23, because Rule 23 doesn't appear in that list of exceptions from supplemental jurisdiction in 1367B. That's why he seems to think this statute is so very clear. Let's just take a look at that again. I mean, there it is, friends. Black and white, subsection B. Supplemental jurisdiction is not available under subsection A of 1367, but only in cases in which a plaintiff is added under one of those specific rules and Rule 23 doesn't appear, that's a clear old case of exclusio unius if I ever saw one. Congress included several specific rules of federal civil procedure in which there would not be a supplemental jurisdiction over plaintiffs where the court's subject matter jurisdiction is based entirely on diversity. Conspicuously absent is Rule 23 class actions. Something I find personally affirming, I guess, in a way, is that Justice Kennedy, even though he says, I don't have to consider legislative history if I don't want to, because there's no ambiguity here, he sees fit to point out a strong argument for why legislative history has to be taken with a grain of salt. Page 234, he describes how this particular House report was problematic in exactly, my own experience with the asbestos legislation was problematic. It's easy to abuse these things. It's easy for people perhaps to make them serve purposes that perhaps weren't the purposes of Congress. Okay. All that said, though, in a certain way, you got to love Justice Stevens' dissent. Starting on page 235, he says, listen, you can call it unambiguous if you want, Justice Kennedy, but as Justice Stevens says, ambiguity is apparently in the eye of the beholder. And he says, for that reason, I remain convinced that it's unwise to treat the ambiguity vel non, that is, or not. I don't know why lawyers do that. The phrase vel non means or not. Lawyers throw it in. But the ambiguity or not of a statute as determinative of whether legislative history should be consulted in Justice Stevens' view shouldn't depend on this finding of ambiguity because it's too hard for judges to agree what's ambiguous and what's not. All right. Well, that's kind of statutory interpretation. For what it's worth, Allapattah, again, is in there to give us one last chance to get a sense of, get a snapshot of what the current status quo looks like. The current state of play amongst modern judges applying the law as it is applied currently. So that's statutory interpretation. I really look forward to the review session on Wednesday. I hope this video was helpful. As ever, please feel free to let me have questions. Come to office hours and talk about it. I think online learning in a lot of ways is not ideal for you, and I feel badly about that. And I always think that recorded videos are kind of more problematic even than live interactions. So if anything here didn't make sense, please do let me know, and we'll work it out. All right, hang in there. See you Wednesday.